All right. Welcome to our audience and ourselves and our panel to what is the Contracts Roundup panel. So it's hard to talk about these items under one umbrella, but I think the panelists will find a way to pair their papers together, or if not, we'll try to do that at the end with our audience stimulating participation. So we've got, first we're going to have Suren is going to speak, and he's from the Tilburg Law School, a PhD researcher from the Netherlands, and his objective of his research is to study the practice of corporate governance in non-listed business forms, which offer strong flexibility and autonomy. And today he's talking about the governance of publicly traded LLCs. And then we will hear from Tom Barton, who swears that he won't talk about everything on all of his slides, but I don't trust him because the title of his paper, Understanding and Utilizing Techniques, Visualization Techniques in Contracting, means that he is going to rely heavily, I'm assuming, on his visual slides. Tom is, of course, at Cal Western and has been writing and thinking about these areas for quite some time, and preventative law and alternative dispute resolution and problem solving and lawyering for the future. So I assume his remarks will have something to do with those themes. Third, we will hear from Tibor Tajti. And he is from the Central European University, where he is going to talk today about normative legal theories and contract asymmetry. He has also, all of our speakers are quite well pedigreed and world-renowned, so we have quite an international panel for this Contracts Roundup. He is now at the Legal Studies Department of Central European University in Budapest, and has also, that school has accreditation in New York as well. He has taught in all sorts of areas of the program, common versus civilian versus emerging systems of law, and various prongs of financial law. So his paper, I think, will tie in nicely with the two prior to that, and then we will have Manuel Ustet, who is at Florida State College of Law, and he has written extensively in the area of inconsistent boards, procrastination in the law, transitive risk and financial regulation. And today he is going to be talking to us about timely reliance, but I'm sure it will dovetail into those corporate law themes, as that's the area of his, much of his recent scholarship. And then last, but certainly not least, we will hear from Marc Roark, who is a colleague of mine at Savannah Law School, and he was originally slated for the Remedies panel, but they decided it made sense to incorporate him as the dovetail on this panel, which is the Contracts Roundup, and he will speak about payment systems, consumer tragedy, and ineffective remedies. He has taught at other law schools, and I try to remind him that wearing a bow tie at these types of things makes everyone think that that is what Savannah means to the world, but he actually wore that bow tie when he used to teach in California, and he wears it ironically, so it doesn't necessarily mean that that's what Savannah Law School is all about. And I'm the moderator, Caprice Roberts, and I'll try to keep it to a minimum, and we'll go ahead and get started with Suren now. Thank you.
Okay, thank you very much for the introduction. I'm also grateful to the organizers of the conference for this opportunity to present my work here. I titled my presentation The Governance of Publicly Traded Limited Liability Companies, and this is a part of a larger project. I'm looking to the governance agreements in business forms which are providing wide flexibility, autonomy to their members, and my main objective is to see what provisions do they use in these agreements, how are they choosing the governance structures as opposed to corporations where most of the provisions are mandatory, while here are default rules, which means that the parties can waive these rules. But in this study, I will focus on, in this presentation, I will focus on publicly traded limited liability companies, and the research is comparative. I'm looking to several countries. I've started from the United States, and because in Europe there are not many specialists in this field, I would be very happy and honored to get any comments and suggestions which I can use to improve my work. Well, what is the problem here? there is a fear in research and also in practice by the default nature of the rules in LLC statutes, they let the members, they allow the members to waive standard corporate governance practices and investor protection rights, and this is putting the investors under risk if the company is offering units to a wider public. A few months ago, there was a special report in The Economist, and they also, the main message in this report was that due to different taxation rules and due to default nature of the statutes, LLCs are changing the face of American capitalism. So my research question is, to the extent that LLCs are subject to less regulation, do they really distort standard corporate governance practices and investor protection rights? If we look to the prior research, the conclusion is probably yes. Here on this slide, I have a brief summary of all works in this field. Most of them are empirical studies, and they look to specific rights in the governance agreements in LLCs. Some are listed LLCs and LPs, some are non-listed. And the conclusion is that in most of cases, investors, minority members in these companies are less protected compared to corporations. For example, the first study, it looks to specific right of minority members. In the case of delisting the shares, the interests of a company from the market, and they conclude that minority investors are less protected. The same is in other studies, and one difference is the last one. The last study is by two economists, and they didn't look to one specific right. They looked to several rights in the agreements, and they also tried to compare this with ownership structure, because in several cases ownership can be substituted to legal rights, contractual rights, as it allows to align the interests of controlling members and managers with the interests of minority investors. This is an important point, and based on this and also taking into account the predictions of theory, I started from the proposition that in order to attract investors, these companies have to offer something. If they are waiving specific rights, it means that probably they offer something else in exchange, or they use other, if not rights, other mechanisms to as substitutes to legal rights, to contractual rights. So the main difference of this study from previous ones is that I tried to first to take into account the whole agreements, governance agreements in these companies, to see if some rights are waived, what are the alternatives, and also to take into account other factors which can be substitutes to legal rights, such as ownership structure, such as the composition of boards of directors, the practices of boards, profit distribution practices, and some other factors. My data, it comes mostly from the ACC's Edgar database. I searched in the annual reports of all companies, listed companies filed with the SEC during 2012. I searched for three main keywords. It's LLC agreements, operating agreements, and limited liability company agreements, because in different statutes use different terminology, and I didn't want to limit my results to one or several particular states. The result of a search is more than 900 operating agreements, mostly non-listed, and more than 700 are from Delaware, and only 20 of these are listed. The rest, as I mentioned, are non-listed companies. In this presentation, I'm focusing only on listed companies, listed LLCs. The rest of the data on ownership, on board practices, board composition also comes from mostly from reports filed by these companies with the ACC. Several words about my coding criteria, how I define them. I can divide them into three main groups. So first group is background information, which is the name of a company, state of formation, principal place of business. A second group is information about ownership. And here I look to ownership at two dates, the date of listing and then the date of, the second date is 2012. I also look to the ownership by managers, ownership by controlling founders, controlling members, and the divergence between voting and economic rights. And the first, the third, the main group, it's, here are the questions which deal with the agreements, with the operating agreements. And here I defined the variables based on the differences of LLC statutes compared to corporate statutes. For example, if a specific right, specific rule in a corporate statute is mandatory and similar or functionally equivalent rule in an LLC statute is default, I inserted a question to see whether the members of these companies are changing or waiving these default rules. So in totally I have 84 questions in my scorecard. I didn't include it in these slides, but it's attached to the full paper, and if someone is interested can take a look to all these questions. Key findings of the study of the agreements first, and I think one of the most important key findings is that the founding members are using default rules, they are waiving these default rules to first to entrench their control, and second to enhance their decision-making power. They do this by using dual class voting structures, shares. They do this by inserting to the agreement specific rights to appoint the majority of board members or to appoint officers. They do this by pooling their interests in a holding company, something similar to voting trusts, and they do this by using shareholders agreements. And then I could also see in these agreements that in most cases, minority members in all these sample companies, they didn't have right of appraisal, they couldn't resign from the company, and also they didn't have preemptive rights in the cases of new share issuances. But the agreements, almost half of my sample, they inserted specific distribution rights, which means that these companies were obliged at the end of financial period, at the end of reporting period, to distribute among the members all cash which the company has. And also interesting is the comparison, is the study of fiduciary duties of managers and members. In none of my sample companies they waived or restricted the duties of members, because these fiduciary duties are considered as one of the main difference of LLCs from corporations, because here members and managers, they can waive, they can restrict, or they can limit the liability for the breach of these duties. So none of my sample companies, they waived or restricted the duties of members, but some of them restricted the duties of managers, and almost all sample companies, they limited the liability of managers for the breach of these duties, with the exception of some special cases, such as gross negligence, willful misconduct, or actions in bad faith. And when I tried to see what is the correlation between these provisions in the agreements, and here to see which provisions were tended to be used together, which provisions were less likely to be used together, and I would like to attract your attentions to the numbers which I circled with red and green. These are significant results. And first red numbers circled red. You can see the first line, this is strong control of management, which I mean strong control of decision-making rights. And you can see that in all these cases, not all, but there is a significant correlation with larger ownership by controlling members, by founders, economic ownership, which means that if they have strong controlling rights, they also have large economic interest, and hence they are, their interests are aligned with the interests of minority members. Or the same is waiver of the manager's liability for breaching self-dealing duty. Again, there is high correlation with the large economic interest by the founding members, and also more than 5% economic interest ownership by managers, which also means that managers have aligned interests with minority members. And then green results. These are strong minority protection rights, and you can see that usually they appear together, and usually they appear in cases where controlling members and managers, they don't have economic interest in the company, which means that there is a risk that they can take decisions not in the interest of all members, and hence minority members in these cases, they need more protection. And the last thing, in the middle here, it's half circle because the result is not significant, but the fact is that in all cases, when these companies waived, restricted, or limited the liability of managers for the breach of self-dealing duty, they included in the agreements special rules on transactions with conflict of interest, meaning that in these cases, non-interested board members had to make decisions. So here we can see that some provisions, they are in contractual provisions, they are used as alternatives to protect the rights of investors, and when ownership comes, a substitute. In a similar way, I look to other factors like board structure, but because of lack of time, I will only discuss one of them. I will only focus on the dividend practices, distribution of profit in these companies, because in theory there are two predictions. First, that these companies, LLCs, they distribute more cash than corporations, listed corporations, which means that because of they are retaining less cash, managers have less discretion in decision making. And the second prediction is that because they are distributing more cash, these cash distributions, higher dividends, they have a role of kind of compensation for weaker investor protection. So I looked first on a figure which is on the right side. I compared S&P 500 companies with my sample companies to see what is the difference between the annual dividend yield, and you can see that in S&P 500 companies it's around 2%, and when in the sample LLCs it's around 7%, which is quite significant difference. And then the figure on the left side here, I mentioned about specific distribution rights in the agreements. These are the rights when the company is obliged to distribute all available cash. There is a concern that these provisions are defined very broadly, and they give broad discretion to managers. And because my sample was half companies had these provisions and half didn't have, I compared these companies to see whether this broad definition of this right is it effective or not. So this down line, it's companies which didn't have this provision in their agreements, and this operates companies which have, and again you see that there is a difference. So even if defined broadly, these provisions, they are effective, they work in practice. And I looked also to board practices in a similar way to the role of market disciplining, which is important because as they distribute all cash, they are all the time they have to go back to the market in order to be able to attract these financial resources, they have to develop investor-friendly reputation. And then the role of standardization in governance structures, because standardization not in a sense that they are not using the default rules they do use, but in the sense that there are kind of clusters of governance practices, and each company which is going to an IPO, it's using one of these structures. So to conclude, the study shows that it's true that they distort standard corporate governance practices as opposed to corporations, but at the same time they either offer alternative rights to the members, minority investors, or they use other factors such as ownership or board practices or dividend distribution practices as substitute to contractual legal rights. So thank you very much. And as I told, I would be very happy for your comments and suggestions.
Since many of you came in late, I'll let you know our next speaker is going to be Tom Barton, and we're going to keep tightly on schedule. He's going to speak again about understanding and utilizing visualization techniques in contracting, and he is from Cal Western. Thanks.
Great, thank you. Oops, no, let's see, I just want to get those off. I hope I didn't, there we go. thanks so much for everyone at the school for inviting me to be here, and to my fellow panelists and to the audience here. So I'm talking about visualization of contract documents. Oops. Okay. Let's see, why am I not moving? I'll just move this way. There. So my presentation is going to involve first a conceptual point, then it's going to identify a problem, and then it's going to offer at least a very partial solution. In my style, I'm going to give you a little précis of all three components of the talk, and then I'm going to circle back and amplify on the conceptual point and then the problem itself and the potential solutions that I see. First, as part of a kind of an ongoing thought experiment that I have made, I wondered what law would look like if we imagine it through a lens of relationships, rather than the typical lens of rights and duties. And when one does that, it becomes pretty convincing in the area of contracts law. And so that's my conceptual point, that it can be quite fruitful for us to imagine contracts as a set of relationships that establish in whole, in their workings, various rights and legal duties. Now here's the problem, that the relationships that comprise contracting are chronically just not as strong as they ought to be. And that means that contracts are not as valuable to our society as they might be. They are not as functional as they might be, because the relationships that underpin them are relatively impoverished. Well, what's the cause of the relative weakness of these relationships? Well, in part, it is that contracts users read their contracts quite infrequently. We all know that. And they understand them inadequately. We all know that. That creates disincentives to reading contracts, because you wouldn't understand it anyway, and even if you did, you wouldn't be able to renegotiate most of the standardized clauses. Secondly, it's a disincentive to even attempt to comprehend them. And thirdly, it's kind of a disincentive to use contracts. Well, what are the reasons why we have these disincentives? First, the contract language is much too technical and much too long. Everyone knows that, I think. Less visible to us is that contracts really are organized around ensuring or avoiding legal liability, cabining the relationships into very clear and secure and relatively small boxes of duties, and as big a box as you can possibly imagine, and secure, impermeable as we possibly can, of rights. Thirdly, though, contracts by their structure, and they build in relatively few frameworks for people to communicate in a flexible and valuable way of mutual understanding and win-win opportunities. Contracts don't prompt the creation of new opportunities in the way that they really might. All right? So what's my partial solution we're going to talk about today? Well, ironically, it might have to do with building better documents. That's ironic because most of us think of a contract as basically a document that creates rights and duties. And I'm asking us to think of contracts instead as a set of intersecting relationships. But ironically, my solution says that if we build a stronger document, a more useful, a more functional document, that in turn will strengthen the underlying relationships. And that in turn will build out stronger functionality for contracts. This possibility that I see of building stronger documents is going to use visualization techniques. They, I think, using graphic images to accompany words in a document, they will make contracts more vivid, much more easy to understand. They will make the contracting process easier to plan, because kind of ironically, because I've tried this, if you are forced to add pictures or graphical images to the words that you use in a contract, it requires you to think in very different ways and plan out the entire contract, and to conceive of that contract in your mind in much more imaginative ways than otherwise you would find through solely using legal language. And it helps people better to draft and read and understand and to implement contracts, because very frequently, almost always in fact, the people who implement the contracts are not the lawyers who draft them. But it's imperative for people who are implementing contracts to be able to read and use those contracts to know what their responsibilities may be. To the extent that we can make that easier for people, everybody is better off. It will also create stronger communication patterns between the lawyers, i.e. those who draft the contracts, and those who use contracts, and those who want to create it, usually the sellers, and those who have to implement, usually people within an organization. And to the extent that we can build out those stronger communications, we will help the lawyers create better contracts. We will help bring in a stronger functionality of innovation in the contracts by putting the parties to the contract together in a communicative way to think about how might they, even in the middle of a contract, how could they do things better, and what comes next in the future for their cooperation, all of which requires people to be put together and to be able to talk to one another. And contracts should facilitate that, which it doesn't. All right, so now I'm going to circle back and take first the conceptual point about relationships, seeing contracts as a set of relationships. Well, I think that there are really three of those. First, it's an exchange relationship that voluntarily transfers goods or services one to another. Secondly, there are personal relationships created in contracts. We all know that is true, even though we scarcely ever talk about it. There are qualities that are embedded in the connection that people make on a contractual basis, involving qualities like trust and loyalty and empathy and cooperation, all very positive. And on the other side, being realistic, we know that there are emotions like suspicion and competitiveness and potential exploitation. But for good or bad, we should just not ignore that there is a personal relationship that is there, and we should do more with it. Thirdly, of course, there is a legal relationship that secures the rights and duties in the agreement so as to be protected by the state where need be. So this is, for me, what contracts looks like. A set of three circles representing three relationships which should overlap in a harmonious and pretty well balanced way. Okay, so if that's contracts, what's the problem? Well, there really are two problems here. The first of which is that there is basically, what has happened is that the three circles, which should overlap and be related one to another and work together, they've diverged one from another, so that diagrammatically we can see the exchange relationship, i.e. the business people who want a contract created, live in their own sphere, and they only go to lawyers in the legal relationship at the end after the deal is done and say, make this happen, essentially. But there's no connection, or very limited connection between them. And as to the personal relationships, that gets shunted off by both of those parties. So I call that the communication problem, the divergence of the three circles. The second problem is that there's a relational imbalance. One of the circles has gotten relatively larger than the other two, and that creates some kind of dangers. And that's the dominance of legal relationships and the dominance of lawyers in the domain of contracting. That all sounds sensible to us because we're all legally trained. But if you talk to business people and implementers of contracts, they don't see it quite the same way. And the point, again, is to increase the value and functionality of contracting. If there were a better balance among the relationships, that would happen better, I believe. Okay, so the problem then of both lack of communication among the three relationships, and second, the relational imbalance, domination by the legal circle, it manifests itself, this problem, in a variety of ways. You know, the basic dilemma is that people have no choice but to make contracts, and certainly in a business-to-business relationship, but even as consumers, that is certainly true. The users have been largely marginalized in this, and that in turn impairs their personal relationships because their personal communication is kind of pointless because it's kind of dominated, the vocabulary, and some of the organization is dominated by the legal anyway. So what does that mean? For consumers, that means potential exploitation. It means a power game, and that's what contracts are not supposed to be about. For business people, it means that they underutilize their lawyers. Sometimes lawyers hear my message as being threatening to them, that I'm trying to diminish their role or their importance. Scarcely, the opposite is true. I value what lawyers do. They have so much more to offer in the creation and implementation of contracts. They're underused by their clients, however, because of the lack of communication and the relational imbalance. Secondly, if we had better contracts, better relationships in contracts, we would have stronger internal institutional organizational patterns. Organizations would function better if they were united in communication about the making of their contracts, both internally and externally. And thirdly, for business people, it means this lesser opportunity for innovation that really could be spawned by better contracts. And for everybody, it just means that we're going to create problems where we easily could prevent the problems. We're raising transaction costs needlessly. We're not reaching the relational goals that we really should be getting at here. What I want to do, because of lack of time, is kind of move to the partial solutions that I think are available. There are actually 4 that I kind of work on at various times. We could have differentiating contracts, ones that imagine that contracts should look radically different one from another depending upon the factual context or the purpose of the contract. It's a kind of a one-suit-fits-all approach to contract drafting. It need not be the case. Branded contracts is the idea that you can, as consumers, buy off-the-shelf contracts from trusted organizations like Environmental Defense Fund or Sierra Club that just have trust to sell. And you could insist on that. Third, collaborative contracts. And finally, visualized contracts. And that's the one that I'm going to talk about today. So, importantly, this is not meant to displace words. The words would govern. This is just a device to help make contracts more vital and have better communication. So, graphic images can do a lot. They can provide clear sequences of ideas or tasks. They can show how things and people fit together, and they can give an overall sense of purpose. But to do visualization well, you have to know your content extraordinarily well. You have to use your imagination about how people will approach documents, and you'll have to use images that somehow communicate something significantly. So, I mean, here are signs. Sometimes images stand fully alone. We know traffic signs, art symbols, etc. In other contexts, we use kind of little pictures that help us kind of make associations, imaginations in our mind, like that one there. Sometimes a picture can be 1,000 words, where if you're selling something, you can take 1,000 words to describe it, or you can show a picture of it. It's very, very easy. Other things, more conceptual matters, are harder to use an image. You have to grasp a metaphor here, like the idea of breach, and the chasm there with people on both sides indicates breach, or reciprocal exchange. Or the idea of invisible terms. I love this one, of the poor guy who's captured by the statutory symbol there. Or, you know, relational expectations of people. Still, right, we have there are other functions that can be done better, more easily than the ones that indicated there. For example, many of us who've worked in the UCC know that the INCO term, free alongside ship. Now, that's made into an acronym because it's so difficult to describe all of the rights and duties that flow from use of that particular term, right? That's why we have an acronym for it. Well, you could create a graph that shows exactly the movement of goods to a ship, to a customs office, to a crane, to a loading on one ship, to an offloading, and all the way at the other end. And by use of a bar, show items like when the risk of loss passes and when ideas of ownership pass and where the costs change from one party to another. It's just much easier to understand. Or here's another kind of diagram that's used. This is to indicate sequence of events. Now, if I'm implementing a contract, this is very important to me. But what this is from the Scottish government, and what they have, this is about their procurement as the Scottish government, and it uses a subway map as the underlying image, and we're all familiar with that image as a way to indicate going from one place to another. Well, what you do is describe it in words, and then describe the sequence in a subway map. Now, sometimes, if there are conditionals in a contract, which are very, very frequent, you can use algorithms or flowcharts, and we're all kind of familiar with that kind of chart. But finally, if you're extremely good at this, you can put it all together and create a kind of a summary chart. This one is scarcely readable from the back, but this is I didn't create this. It's a brilliant tying together of all kinds of rights and duties in a contract that is, at a glance, indicative of what people's responsibilities are. I think a chart like this would be invaluable to someone actually implementing a contract. So with that, I'm finished. Thank you very much.
All right, we'll move to our third speaker, Tibor Tajti, and he again is from Central European University and is going to speak about normative legal theories and contract asymmetry.
First of all, I would like to thank also for the invitation to Professor Martin Hunter, and thank you very much for coming. As it has been introduced, I'm coming from Budapest, Hungary, and from a university which is truly international in the sense that we don't really teach Hungarian law, but rather we teach comparative law, etc. And I have tried to come forward with a topic which, in my understanding, is a kind of transnational law, but of a different sort from, let's say, from the CISG. And it is a topic which, in my understanding, should be of equal relevance to both Europe and the United States. And this is the issue related to contract asymmetry. And the other part of the title basically explains my thesis that normative legal theory should come forward with answers, a number of answers on this issue. Okay, now, the discussion about contract asymmetry primarily will be based on business format franchise. And essentially, this is I think, the pretty good clue for the whole discussion, because the first reason why, because it makes sense to deal with this topic, is the business format franchise as a extremely successful contract, which was invented in the United States during the 1960s, 70s, and from where it had spread to Europe. And now, with some delay, business format franchises basically has become one of the most successful import business models and contracts from the United States. So this is what links the whole story. And the first reason is exactly related to franchise. You may also find, though, some other reasons. I'm not going to deal with those issues because the time will let me just go through franchise as a paradigmatic asymmetric contract, but the truth is that if you take a closer look at, let's say, international literature, you can find that you may find some other reasons which basically justify exploring the issue of contract asymmetry or balance contracts. Very briefly, you do have concrete empirical data that in international cross-border contracts, quite very often, business friends, the primary criterion for the business parties is to choose a law which is balanced. Now, I still don't really know what is exactly meant by the balanced contract because I haven't really found the answer to that issue. But with reason two, I don't really want to deal with because we don't really have time. But rather, I would like to take a look at franchise because franchise links United States, Europe, and the other parts of the world where franchise has become really successful, like China. Okay. And I have a number of hypotheses. One of them is I do think that franchise is a paradigmatic asymmetric contract. In other words, you don't really have franchise without certain level of asymmetry, irrespective of the fact that we don't necessarily know exactly what is exactly meant by asymmetry. But it's clear, if you go through the literature cases, that some level of asymmetry, meaning that essentially the franchise is in the position to dictate many, many things, has heavy controls, is accepted. The second thing is that contract law, contract theory should answer this question. If you take a look at the related literature, primarily again United States, the leading authors, they say that franchise problems are still primarily contract law problems. We have regulatory issues, other issues, but it's still contract law, and therefore contract law has what to do. And my third claim is that actually it would be possible to deconstruct asymmetry, taking franchise as the benchmark and model on the basis of the analysis of, let's say, typical standard form franchise contracts. And finally, my claim 4 is that I think that the answer should come forward in the form of a pluralist normative theory, meaning a theory which is specifically tailor-made to franchise contracts. And in some sense, coming from Europe, where we are kind of lag behind developments, we have less developed franchise laws. And when I talk about Europe, I don't really mean just the European Union, but the national states as well. Therefore, we kind of legitimately expect the United States as the source, cradle of business format franchise for perhaps to come forward with answers to these questions. So, and the third introductory point is that this issue has both theoretical and pragmatic dimensions. Okay, why franchise asymmetry? I have very concrete reasons. I have taught for a number of years also at the business school, and I had students who then become franchisees of American large franchise corporations. And we have covered franchise contracts, analyzed them as a newcomer successful contract forms. And then I already realized that there are some issues with the way franchise functions. And that was a concrete reason because of why we have, with my colleague, Professor Stefan Messmann, we have published 2 books titled The Case Law of Central Eastern Europe, not just for the sake of, for the first time, to follow the American teaching method to offer cases in English language from Central Eastern Europe, but also to see what has happened with franchise and similar newcomer contracts in this particular niche of Europe. Because as you may know, until 1990, these were socialist countries, and basically franchise and these modern types of advanced contracts were not really known. And in only 3 countries, but we managed to find franchise-related cases. One of them was Poland, the other one Hungary, and the third one was Ukraine. And the Polish case is most interesting because the court, the case reached the high courts, and the issue which was presented to the Polish courts was exactly what is asymmetry and what level of asymmetry should be tolerated in case of business format franchise. And in those days, in Poland, there was no, and still there is no specific franchise regulation or law. And interestingly, the Polish court, they, I think, made a right decision because it cracked and basically decided that asymmetry is key, crucial to business format franchise, and therefore it should be tolerated. Now, Europe, going on, this is not just Poland. It's interesting that Germany is in the same shoes. So Germany as a leading European civil and legal system still does not really have franchise regulation. Franchise law is essentially contract law resolved through contract mechanisms plus some industry self-regulation. So no regulations of other sort. Why is that a kind of a problem with that issue? I cited this quote from a book which was published, as you may see, in 2013. This shows you also that European literature is lagging behind. So the first books which go really in depth into franchise-related issues are appearing only these days. This is a book published from 2013, and let me just brief it because it clearly shows you why does the problem have a very pragmatic dimensions. Although franchising is a specific, distinct, and uniform type of commercial activity with a positive influence in the European Union, which stimulates economic activity, it is not fulfilling its potential. Now, if you compare the economic data, United States versus Europe, and this is what Abel is referring to, that Europe is, lagging behind substantially. The regulatory environment in the European Union is at least in part responsible for this underachievement. So we have a problem with franchise law or regulations in Europe. Okay. Now, if you take a look at the United States as the cradle of business format franchise, well, you may get various kinds of impressions. First of all, I was not in the position to find the answer to the question, what is franchise asymmetry and what level is normal or should be tolerated by the law? You may find examples like this. Practicing Law Institute, a student was asked, what was the lesson? The lesson was, don't buy a franchise. So something frightening, which goes back exactly to the issue of asymmetry. If you take a look at the rest of the literature, you have developed many scholarly articles, basically the biggest number of law and literature on that. You could already see that you could divide the literature into two groups. Those ones who are kind of siding with the industry and those guys which are siding with the franchisees. So the victims of franchise asymmetry. And then if you read them, as you may see, different claims come forward. And then again, you have the issue, fine, what is the right answer to? What should be the tolerable level of asymmetry? Okay. Further on, United States, I have found also this thing. So obvious, and this is why I claim that asymmetry, maybe not named this way. So it's not really clear whether it's a franchise or opportunistic behavior controlled by franchisors. So the term asymmetry is not necessarily used. But I think that it gets to the heart, to the essence of the problem, and that is why I used it. So I don't really claim that this is the absolutely right term which should be used for this set of problems. But if you did not know that, basically the legislative activities is ongoing in the United States itself, showing that the problem is present. So there is no solutions, proper solution have been reached even in the United States. Okay. Now, why contract law? This is the leading, I think the leading claim that essentially franchising is extremely important, but in a sense, it is a contract law problem, still. Okay. What does contract law offer to franchise law? That's the issue, whether it's appropriate or not appropriate. If you take a look at what contract law offers in the United States, but also in Europe, which, especially in countries where there is no specific regulatory law, is that you have essentially exceptionally applicable tools. We have heard during yesterday's presentations today a couple of times the doctrine of unconscionability have been mentioned, that it's very vague. You have problems, and I can refer back to that. So in other words, obviously, these exceptionally applicable contract doctrines are not necessarily appropriate to handle the franchise asymmetry. Okay, and the repercussions in the United States are, I think, most properly visible because United States has also the most developed regulatory structure, meaning regulations imposed, which curb essentially contract law. And you have three solutions, three models, which is not replicated in Europe and not really discussed even in Europe. Then finally, this train of thought led me here that, well, contract theory at the moment has no answer to the issue of that was raised to the Polish court. What is a contract franchise asymmetry and what level of franchise asymmetry should be tolerated? You don't really have the answer to that. And therefore, the question is, what can legal contract theory do in this respect? And if you take a look at some of the theories which originate in the United States, like the theory of incomplete contracts, the theory of relation contracts, they have focused pretty heavily on franchise contracts, and they have highlighted, explained quite the nature of franchise contracts more closely, but still they have not answered the question, what is asymmetry and what level of asymmetry should be tolerated by law? So to finish my presentation, I think that franchise asymmetry is important exactly because of the economic importance of franchise contracts both in the United States, Europe, China, and elsewhere. And the issue of franchise contract asymmetry could be and should be tackled, and the theory could be developed on this issue. And theory in the form of a pluralist normative theory, meaning a theory that will fit only franchise and not necessarily sales contracts. Thank you very much.
All right, we're actually a little bit ahead of schedule because you all are watching my prompts and even ending before I'm asking you to end, so I appreciate that. Next up is Manuel Ustet. Again, he is from Florida State University College of Law, and he is going to be speaking about the optimal timeliness of reliance, taking off where the law and economics scholars have focused us in on that important reliance moment. Thank you.
Okay, thank you. And so, as was mentioned, I'm going to be talking about, the optimal time to rely. When should a party to a contract incur reliance costs or invest in reliance? And in particular, what I'm concerned about is how our understanding of reliance and reliance investments would change if we take into account time-inconsistent preferences. Or more generally, we take into account the preference that people generally have for immediate gratification and the fact that they tend to mispredict their future willpower. They tend to be over-optimistic about their ability to stop eating cake tomorrow or start exercising tomorrow, and so on. But let me just begin by setting forth the general framework that I'm concerned with. So I'm looking at the standard law and economics optimal reliance approach, and we'll assume that there's a buyer and a seller. A buyer will have to make a decision about whether or not to rely and choose the optimal time to rely, and the seller will make a decision about whether to breach or to perform. Now, under the general understanding, if we only give reliance damages to buyers, or if we allow for renegotiation, there will be under reliance, and if we give expectation damages, we will have over reliance. We will have reliance in some cases in which the parties will, as a whole, as a group, would be better off if there hadn't been reliance, okay? And so what I want to explore is how this general model or understanding of that general model would change if we take into account time-inconsistent preferences, okay? So generally, what I will look at is two types of self-control problems. The first one is procrastination, and by that I mean something very specific, which is that somebody has a long-term preference to do something, let's say tomorrow, and they have that long-term preference because from the perspective of today, that will maximize their returns. But when tomorrow arrives, they give greater weight to immediate gratification, and they may reverse their original decision. On the other hand, somebody may preponderate or overconsume if today you have a preference not to consume tomorrow. Let's say today I'm eating a piece of chocolate cake and I decide that it's my last piece of chocolate cake and I definitely do not want chocolate cake tomorrow because it would maximize my intertemporal utility, i.e. my lifetime utility, not to have a cake tomorrow, and then tomorrow arrives and needless to say, I'll have cake. Okay, so what would lead to either procrastination or preponderation? So the general way to model this is to assume that a party has the ability to make a decision from a long-term perspective. They make a general cost-benefit analysis in the same way they would under any kind of standard situation. However, if at the time of actually following through with your long-term preference, with your original decision, if at that time you have to make an immediate investment or incur an immediate cost to buy something that you'll receive at some time in the future, you're more likely to, or you may have an incentive to procrastinate, i.e. you will give greater weight to that immediate cost and give the same weight that you did before to the delayed benefit, and you may reverse your preferences. In the same way, you may have a decision that will lead, let's say I've made a decision not to eat cake, tomorrow arrives, now I get an immediate benefit, the cost from eating that slice of cake is delayed, and I may reverse my preference and overconsume. So procrastination, we may procrastinate, starting to exercise or diet or writing the great American novel, or having children or getting married, we procrastinate doing a whole bunch of things. And we may overconsume, addictive products and so on. Okay. So there are 5 general contract law issues that I want to tie together with in this, taking into account timing consistent preferences. Number 1, the optimal level of reliance, how much to rely and when. Then there's a question of opportunistic behavior, which, I just will mention and will leave aside, but, we may, if somebody has timing consistent preferences, they may overconsume opportunism in the same way they overconsume other things. Something that I've called like nibbling opportunism. You may, take nibbles each time saying, this is the last time I'll do this heinous act to my contract partner. You may leave contracts more incomplete, which I'll also leave aside, but you may also procrastinate acquiring information. Information is an investment. When you acquire information, you invest to get something in the future. And you may also procrastinate engaging in an efficient breach, okay? To those who believe in efficient breaches, so we'll just bracket this for a second and say that if we believed in efficient breach or optimal breach, a party may breach too late, or sometimes they may breach too soon, and it will be inefficient, okay? So let me, so one thing that we need to just at least point out from any kind of model that takes into account changes in preferences over time is how do we measure what is the true preference or what is the welfare criterion that we're going to use to try to measure to see if somebody is actually better off delaying or they're actually procrastinating. And so welfare criterion that is most commonly used in models of time inconsistent preferences, and the one that I'll adopt, is that you want to follow through with the preference that you have from a long-term perspective. So if I don't have a piece of cake in front of me, or a cigarette, or a glass of wine, but I'm thinking about consumption tomorrow, or a costly investment tomorrow, from that long-term perspective, I don't have my preferences distorted by immediate gratification, and my claim is that we should use that as the measure of for measuring losses. Okay, so my principal argument regarding reliance is that because reliance involves an investment that will yield a delayed benefit, there will be, all other things being equal, if you take into account time inconsistent preferences, you will have under-reliance. You'll have procrastination in reliance. Same thing in breach of contract, and the reason that I'm talking about reliance and breach together is that they're really, under the optimal approach, they're really tied together. So you have to think about reliance and breach as a whole. Time inconsistent preferences may lead a party to breach too soon, i.e. they may have a long-term preference actually to perform the contract. But if they have an immediate benefit that they can grab from breaching, they may actually breach, notwithstanding a long-term preference to perform. On the other hand, there's also the possibility that a seller has concluded that they're better off breaching, that it will be optimal to breach, but there are certain immediate costs associated with breaching. You have to, not only, maybe hire lawyers, but a discomfort of disrupting a relationship and so on. There are a number of immediate costs associated with breach that may lead to too few breaches. Okay? So under the best possible scenario, assume that you would get your reliance rewards, they're guaranteed, so that we don't even have the problem that we usually assume under these optimal reliance models in law and economics. Assume that there's no reliance risk. There's going to be performance with 100% certainty by the seller. Okay? But even in such a case, one can show that even if the buyer has a relatively small preference for immediate gratification, and if the buyer mispredicts by a sufficient amount their future willpower, the buyer may actually repeatedly procrastinate relying and never rely. Now, this is in a situation where there's no reliance risk, where we know with 100% certainty that the seller is going to perform. Okay? Okay. So a time inconsistent buyer will, and so just to put it, in a very formal manner, if you compare a time consistent buyer, the ones that you find in the standard economic models, with a time inconsistent buyer, we can show that a time inconsistent buyer will not rely any sooner than the time consistent buyer. So they will not rely any sooner, but they may rely later, i.e. they may procrastinate. And so I'm gonna skip that. So breach. So as I mentioned, you may have a time inconsistent seller who may have concluded that it is efficient to breach and they may actually procrastinate breaching, or you may have a seller that has concluded that it is efficient to perform and yet breach due to their time inconsistent preferences. Now, information is important because in figuring out the optimal time to rely or to breach or perform, you need to acquire information during the performance of the contract, and if you procrastinate acquiring information, you may reach the wrong conclusion regarding reliance and breach. Okay. So let me, since we only have a few minutes, let me just give a few implications, legal implications. So number one, if we take into account time inconsistent preferences of a buyer, expectation damages may actually be optimal. In other words, the over-reliance that was assumed actually can be seen as an extra benefit that will provide a sort of insurance or a sort of extra amount that will foreclose or reduce the incentive of a buyer to procrastinate relying. So in other words, one way to get around procrastination is to increase the delayed benefit that a party may get. One way, this extra amount that you get from expectation damages may very well be a way of dealing with, procrastination, or an efficient way to deal with procrastination. But let me just in closing mention two other kind of solutions or ways to think about the reliance problem that are that are not tied directly to time inconsistency, but are tied more to the optimal reliance problem. So one thing would be that we could have a requirement for a buyer to inform the seller that they're about to rely. So you could have a situation in which, you have a penalty default rule that requires the buyer to, if they want to get reliance damages, you require the buyer to tell the seller, I'm about to incur a reliance investment at this point. Please provide me with assurances about the likelihood that you're going to perform or breach. Okay, so that's one possibility. The other one would be to require a buyer to, at the time of contracting, provide information regarding the expected reliance over time that the buyer expects to do during the contract. So in other words, just like in Hadley v. Baxendale, we take into account providing an incentive for disclosure, we could have certain legal rules that get around some of these problems by requiring disclosure before you take an action such as relying, or you provide disclosure before you enter into a contract or at the time of entering into a contract, information regarding my expected reliance over time. Finally, one question that I think is important, at least to think about, is this question about the optimal time to breach when a seller breaches too late. In other words, we may want to have a legal requirement that if you know with sufficient certainty that you're going to breach, that you disclose that as soon as possible. Okay? So that at the time that I know that I'm not going to, or with sufficiently high probability, I'm not going to perform this contract, that you provide disclosure as soon as possible. Okay? One reason or one benefit from doing this is that it's going to provide the buyer with better information before they rely. But there's a second benefit. If the seller can choose the time when they will actually carry out the breach, the seller has an embedded option. They have a valuable option that they are able to choose the actual timing of the breach. And the question is, why should the seller have the value of that option as opposed to dividing it between the buyer and the seller? Okay, well, thank you very much.
All right, and we now are on to our last speaker of this panel, which is Professor Marc Roark. He, again, is on the Savannah Law School faculty, and he actually writes in a number of areas that are outside of contract law, so he's going to bring some of those to bear. Those include property law and law and literature. I don't know if you'll be doing literature today, probably not today, but he also teaches UCC, that's what brings him here to the Contracts Conference. So he's going to address payment systems and some of the consumer tragedies and ineffective remedies. Thanks.
Thanks, and thanks to all the panelists. These have been super interesting discussions. I've really thought all of them were really well done. I want to start with a description of a transaction gone wrong. So back in 2010, Starbucks launched its Starbucks card and launched a mobile platform from which to use Starbucks card. Some of you probably use your phone to pay for your cinnamon lattes. So at the time that they launched the card, a software developer named Jonathan Stark came up with a brilliant idea, or he thought was brilliant, for a social experiment. So he launched what was called this give a coffee, take a coffee. He took a picture of his Starbucks card barcode and posted it online for anyone to download onto their phone. And the idea that, and he put $500 on it and said, you can use my card to buy a coffee and put more money back on it for someone else to buy a coffee. Well, turns out over the next month, it's wildly successful. More than $13,000 was loaded onto the card over this time. About a month later, another software developer decided he wanted to do a social experiment of his own. I'm not sure what's up with software developers and wanting to do their own social experiments. So this software developer shows up at a San Francisco Starbucks with his laptop and hacks into the Starbucks system and drains off all of the money from Jonathan Stark's Starbucks card. And then he posts it online and says, I'm going to sell the access to this card. The starting bid starts at $750. I could buy an iPad with this. I'm not going to buy an iPad with it. I'm going to give the money to Save the Children. Let's find out if you really just want to give coffee away, or if you're really interested in social movements. So at that point, Starbucks shuts the card down, completely terminates the card, and all the money goes away. It doesn't go to anyone else. It does not go back to Jonathan Stark. It does not go to anyone that had any prior right. And the question that comes to bear in this is, well, where did it go? And who gets the money? And why do they get it? And how does that transaction interact in this global ecosystem of payments? And what we're seeing right now is we're seeing a lot of payment instruments or payment technologies come into the market that are presenting challenges to the payment ecosystem. Things like Square Cash and things like Coin present some particular legal problems because the legal system is binary. Largely, when we think of payments, we think about them interacting in one of two mechanisms. We think of them interacting in a credit mechanism, or we think of them interacting in a depository institutional mechanism or some form of a money transfer. What we have in these technologies, we have the technologies interacting in the system by utilizing the ACH transfer system or some other mechanism of transfer, but avoiding many of the legal constraints that bind things like banking, things like credit. So as I described a few months ago at the Clearinghouse Conference, the problem this creates is it creates the instance in which the bank has fully funded the acquisition of funds onto the device, and now the bank is alleviated for any responsibility within the transaction. Now the transaction fully rests on this other third party, like Starbucks, whose only interaction with the consumer is under a contract, so that the contractual remedies are all that remains. Now, this shouldn't be really that surprising, right? Because the payments environment is going to respond far slower to technology. Our payment regulations found in EFTA, found in TILA, generally are premised upon the existing payment ecosystem, not the ecosystem that we anticipate developing. And one of the problems that it creates is when those technologies tend to change the ecosystem. So what I want to argue is a couple of things. Number one, payment technologies that are adaptive to the ecosystem are not necessarily problematic, but those that are transformative, we need to have another way outside of our binary approaches of thinking about how these technologies interact, and that contract remedies often fall short of protecting vulnerable persons in these transactions. So why are these things problematic? Well, one reason is that the lines demarcating the transactions are particularly less clear. Consumers often don't know exactly how they're paying for something, even when they're paying for something in a known type of transaction. And even if they know specifically how they're paying for something, for example, if they're using a debit card or a credit card, they might not know the particulars of how the money gets from point A to point B. Everything behind the veil is particularly obscured for consumers outside of the fact that they know that they had access to funds on one point and now those funds lead to services at another. It's also become blurred from the point of the merchant transactor. So for example, the transition of money storage via ACH network is one that's often been used just to transfer funds between existing institutions. But the access of shadow institutions in utilizing the access in utilizing and access the current network creates some institutional problems because some of our assumptions on how those actors perform don't necessarily play out. So for example, Walmart recently has launched the Bluebird card, which utilizes the ACH network and carries an American Express logo and purports to act like a credit card, but invites consumers to take pictures of checks, to deposit their checks into a money storage account and allow Walmart to hold that money in process for them during that time period. That creates some problems in a binary system in which one might think that they're operating in a banking-like transaction but utilizing a credit-like mechanism. Lastly, what I'd say in that regard is that money storage that originates as credit but ends in prepaid sales also blurs the line between what merchants are doing. So for example, is Starbucks really a money storage entity? Is it an entity that's holding money for future sales? And what happens when it breaches either of those obligations? What happens when, like in the Jonathan's card scenario where Starbucks says, you know, we're not really comfortable with how this transaction started out, so we're just going to shut the whole thing down, as is our right under the as in the terms and limitations. Or if they say that you thought you had this much money on your card, but you really have that much money, and I'm sorry, that cinnamon latte that cost $6, we're not going to be able to cover today. I think this raises an issue of that we talk about in the property world, or that's received some attention in the property world, particularly in Canadian scholarship, of scale. And I'm going to relate it to two concepts in property. One is to gentrification and one is to nuisance. I'm going to start with gentrification. So I articulate an idea of consumption gentrification that happens in these technologies, in which we create an ecosystem of payments and we expect that ecosystem to be responded to by people that it's designed to respond towards. So, for example, I'll give you two examples. One is, imagine the high-end consumer or the high-value consumer that chooses to utilize a prepaid cellular phone device for his cellular marketing. Obviously, prepaid cellular is not marketed towards the high-end consumer. It's marketed towards low-end consumers. The second example is from the Starbucks example. So imagine the low-value consumer, the consumer that does not have adequate resources, who chooses to buy a cinnamon latte and can't really afford to pay for that cinnamon latte outside of other resources. What the payments environment is premised on is it's premised on the fact that we assume by various structures that we can ascertain the risks that parties bring into certain transactions. And that what consumption gentrification as a model challenges in that relationship is that the environment is not always indicative of how people have evaluated their risk. What I would say in general is that gentrification undermines our dominant assumption that filtering is unidirectional, that parties always filter in the same ways, when in reality, parties are filtering in lots of different ways, and that technology makes it easier for parties to filter various constraints. The second example I'll raise is towards nuisance, or the second property constraint I'll raise towards nuisance. And that is, as we think about nuisance, what we think about is we think about the ways that individual parcels of land or individual owners impact the neighborhood or impact those around them, and whether they have a right or whether they have a remedy or whether they have the right to do what they're doing or whether their neighbors obtain a remedy in return. And what this creates is, it often creates, when the law recognizes or doesn't recognize the remedy, it creates assessment problems, because it changes the risk evaluation for how parties thought about coming into the neighborhood. It changes how people think about whether they wanted to live in the neighborhood. If they thought that if they had not thought about that they might have a neighbor that was engaging in illicit drug sales from 2 blocks over, they might rethink about whether their assessment or the risk that they had assumed coming into buying in this neighborhood was adequate. This raises what I've termed as a couple of paradigm problems that technology presents. So I think that there are 2 broad paradigms that payments interact in, the payments ecosystem interacts in. One is the commercial law or the commercial contracting paradigm, which interacts generally with risk, with action, with time. So Manuel, your comments on how timing and efficient breach play in. Time clearly plays in a way of how commercial contracting thinks about constructing remedies, how we think about remedies that arise between parties, how we think about whether parties should have a remedy or should not have a remedy. On the other hand, the payments ecosystem responds to 3 similar but not completely coherently similar paradigms of creating systems that further longevity, systems that create further efficiency, and systems that further confidence in the entire ecosystem, that we can rely on these various types of instruments, and we know that when we use them that they will be supportive. And this is one of the reasons that we probably struggle a bit in thinking about transformative system and transformative payment systems in our binary legal system. We think about that because we think one of the problems it creates is a problem towards the whole ecosystem. That if people are less confident in the use of their Starbucks card, then they might be less confident in the way that these technologies further the entire access to the ecosystem or other similarly situated access points to the ecosystem. And things that might be transformative in a good way all of a sudden become transformative in a bad way. That people no longer trust how they might access their normal pieces of liquidity. Last point I'd make on this nuisance scale gentrification point is I would suggest that most of our system is built on a basis, a construction of risk tolerance with a certain amount of oversight. That most of the payment landscape is premised on the idea that we can understand the risks that we accept because we have a certain amount of risk oversight and we have a certain amount of assumptions that come into engaging in that landscape. And that when we interject or when we create systems that throw that on its head, we encounter a couple of problems. Number one, we may not distinguish the type of parties may no longer distinguish the types of transactions they're engaged in. They may not be prepared to accept the losses or have the means to assert a legal remedy if they were not prepared to accept those losses. That the merchant may find himself in a far better position having pre-selected the forum, having pre-selected the general nature of remedies to avoid losses in those scenarios, and that there's not much institutional movement to alter those conditions, particularly since those at risk tend to be low-value consumers. So what are some of the solutions? I suggest a few things. Number one, I suggest, and since this is an International Contracts Conference, I have to at least suggest one international approach. That the European model in dealing with money storage seems to move beyond our binary approach in the sense that the European model suggests that there could be this third way of thinking about money transfer that doesn't just rely on credit or money storage, but actually invokes and creates some this third category of transaction. So in the U.S., we've had numerous industry participants that have put up a wall to that third approach. PayPal being one of the most prominent that has not wanted to see that third approach. They're pretty happy relying on the contractual nature of the transaction. One thing is to rethink the forums for resolutions of these disputes. So where do these things get resolved? Do they get resolved in courts? Do they get resolved in arbitrations? Do parties like Starbucks or do parties like KCON or Square Cash, do they just get to choose where the best resolution place is? And should there be some other third entity? The Consumer Financial Protection Bureau, for example, has probably made the best strides in terms of rethinking the best places for resolving these disputes. In November, Richard Cordry suggested to Bank of America, Wells Fargo, and others in the Clearinghouse Conference that it was basically a help me help you, and the request was help us provide some means of access for lower income participants in order to avoid some of these shadow bank problems that we face. And the call was clear from the CFPB's perspective. They saw the banks as being a potential partner in alleviating. And we've seen another avenue in that in the recent suggestion by Elizabeth Warren to convert the post offices in a credit form of avoiding some of those shadow banks. I wonder if there's some similar movement if we could think about the payment structure and the way we can latch into federal payment mechanisms. Third, I'd enable greater access or greater collective action in these forms. So, for example, I suggest in the paper a potential remedy is the creation of what's called the unsecured aggregate creditor. So thinking about how collective creditors engage. If you think about Starbucks in 2012, by 2012 on their Starbucks card, they had more than $14 billion in a single year run through their Starbucks card system, and at various points had held cash reserves on that system of between 400 and 700,000. That's a lot of cash. When you think about that, when we posit this endeavor in the role of contract, what we are suggesting is that consumers have given a low interest or no interest loan to places like Starbucks to enable them to act and to further their business. So one of the remedies that I suggest is perhaps we treat consumers as an aggregate creditor in that relationship. So thank you for your time. I've enjoyed it and look forward to comments and questions and wonderful discussion.
All right, thank you again to all of the panelists and of course to Professor Jennifer Martin for bringing us all together in these wonderful environs. And I'm here now to open up the panel to questions either from the audience or of course among themselves. If anyone would like to ask a question from the audience, we'd love to entertain it. Sure.
So I have a question, I guess, for the whole panel, to the extent that it might be relevant to anything you said. But it seems to me that for Marc's paper especially, and Manuel's, and also for Tom's, a lot of the problem is awareness or certainty. That a lot of the things that you see as problems in your paper is that parties to contracts or people involved in contractual relationships are uncertain about things or unaware of things. And they might be aware of it, but the outcome is uncertain, which is a problem running through all of human planning,
economic, contractual, and so is there really a solution for that? And is there a solution that is totally neutral, is what I was wondering. So for example, when Marc was talking about nuisance law, and there is a remedy or there isn't for use in a neighborhood. And of course, I was thinking of the great Louisiana case, Al Copeland, the founder of Popeye's Fried Chicken, who would turn his house into a Disney World display every Christmas. And the neighbors didn't like it, and it took a lot of litigation. And the answer was, well, there's sort of a remedy and there's sort of not. And so it was all about uncertainty. But if it had been certain at the very beginning, when Al Copeland, who, by the way, was the first person to build a house in that neighborhood, if it had been certain to everybody, if you wanted Chevy Chase Christmas vacation style light display here with 500,000 twinkling Italian Christmas lights, this is the neighborhood for you, there wouldn't have been a problem. The problem was that nobody knew about what the neighborhood would be. And I think that's something that runs through so much of any sort of plan, whether it's to buy a home or to have a credit card, or people just don't know. And even if they want to know, it's hard to find out. And so is there a remedy for that across different types of contractual behavior that's neutral? Because if there's a remedy, for example, going back to Al Copeland, if there's a remedy, no Christmas displays, well then the people that like Chevy Chase displays are out of that neighborhood. And so it's not as though, it's not as though any post hoc solution is going to be neutral. It seems like only clear upfront solutions are going to be sort of neutral in that people can gravitate one way or another. I want a Starbucks card or I don't want a Starbucks card. But unless you know in advance, it seems like any solution isn't going to be exactly neutral. It's going to rule somebody out one way or the other.
Yeah, I'm happy to start. Yeah, I think that's a great question, a great observation. I would probably go back and I think nuisance is actually a perfect example of this. I would go to Caprice and Melmade's observation about entitlements and how entitlements are formed and then how they're shifted, right? Because at core, entitlements basically just reflect the choices of the state to adopt one entitlement or not adopt an entitlement. And really what we're asking is we're asking, well, who should internalize those costs? Which party are we going to place the burden of internalizing the costs of this entitlement shift at this particular time? And I absolutely agree with you. I think that these are not conversations that are neutral by any means, because what they end up doing is they end up making the state take a choice to say, well, this is the kind of transaction that we're willing to stand behind, or this is the type of use of property that we're willing to say this adopts our views of what we think society should be up to, right? So I think I'm not sure that I don't think there is a neutral way, but I'm not necessarily problem. I don't find that to be a problem. So.
Well, it depends on which end of the entitlement shift you're on, right?
Right, exactly.
Whether it's a problem or not. And so that's kind of what I worry about. Is another way to say entitlement shift is to say, well, you're screwed.
Yeah.
And if it's phrased that bluntly, then maybe we shouldn't be so happy with it.
So a good example, and the two type, and this goes into the property realm of nuisance, are two nuisance cases that draw on Caprice and Melmade's Rule 3, Rule 4. So the idea in Caprice and Melmade's is that entitlement shifts happen because either in a Rule 1 scenario, you have the right to be free of the nuisance and you can be completely avoided. Number 2, you have the right to be, in a Rule 2, you have the right to be free so long as someone's not willing to pay for the right to commit the nuisance. In Rule 3, it's you have the right to commit the nuisance, bar none. And Rule 4 is you have the right to be free of the nuisance, or to commit the nuisance, but if somebody's willing to pay you to stop, pay an objective level, you have to stop. Right. So two cases. One is a case out of Idaho called Double R Cattle Ranch, in which in which this cattle farm encroaches in on this neighborhood, right? And so the state says, essentially applies a Rule 3 Calabrese Melmade approach and says they have the right to commit the nuisance. And why they have the right to commit the nuisance? Because the state adopts this particular view of the cattle industry in Idaho. This is important to us. So completely an unneutral perspective. So from the homeowner's perspective, yeah, because they now have to have all kinds of smells and flies and everything else. The same, almost an exact same case, but a different result happens in Spur Industries v. Del Webb, where you have the cattle ranch that doesn't expand, but the neighborhood moves into them, and the court now says, well, cattle ranch, now you have to move as long as the neighborhood's willing to pay you. So again, maybe the neighborhood's not really happy the fact that they have to internalize those costs, but at core, it's the state choosing and saying, we value your presence in this place, or we value what you mean here. And I think the same thing happens in contracts and commercial lending, that at a certain point, we either value or don't value the types of transactions that happen, and the state will either endorse it through various doctrinal means or not endorse it or through other limitations. Emmanuel?
So one possible solution is to get rid of all uncertainty, and if we had perfectly complete markets, we would get rid of all uncertainty. But there's actually a danger. And you could have perfectly complete markets by having a security that will take into account every future state of the world and a market to trade them. But that was the dream of perfectly complete markets was what led to the financial meltdown in 2007, because a lot of these derivative products were actually created to get rid of uncertainty, to try to deal with uncertainty and get closer to complete markets. But it turns out that if you get close enough but you don't get there, it may be much worse than having uncertainty. And as far as information, I mean, your phrase about getting screwed, I never understood why we don't have requirements like in adhesion contracts. First of all, a requirement that all print will be very, very small, so that you either know that you're getting screwed, or a requirement that you require disclosure that's saying this contract, under this contract, there's a high likelihood that you're going to get, that is going to be really, really bad.
It needs to be an image of a lion, right?
Yeah. Or,
the lion that Llewellyn talked about, you know that the lion is roaring and it's going to snap down on you.
but it ties into some of the other presentations, because the basic idea is how can we make salient at the time that you're entering into a contract the future consequences, and legalese is not the answer. It may be better pictures, very visual, or a very visual short phrase. Enter into this contract, but please note that you're about to get screwed in the following ways. You will not be able to sue. You will have to go to arbitration. You don't even know what that means now. Trust me, it's really bad for you. And if you require that disclosure, it may actually force the parties drafting the adhesion contracts then to react by,
But then they would change their prices, right?
So they may change their prices. So it depends on how competitive the market is, but it may lead to some reactions in other words, there's a lot of creative ways, and some of those visual ways were actually quite creative. There are a lot of creative ways to transferring information in a salient manner. So.
Thank you for that very productive question. It is certainly true that I'm advocating using visual images, graphic images, to give people tools so that they can understand contracts better and to make contracts objectively more clear. But I'm not addressing the problem of uncertainty. I'm addressing more the problem that people don't talk to one another. I'm addressing more that the system is closed from external input from non-lawyers. And what I'm wanting to do is give people enough understanding of what's might be legally certain, right? Understanding so that they can participate better. and form better communication among the contracting parties and with their lawyers. I see the world kind of importantly moving from tools in solving problems of power toward solving problems of mutual agreement and consent and human understanding. I think that that's the movement of the 21st century, all right? And contracts is maybe the most important tool in getting us there, because those are the presumptions underneath contracts, that people engage with one another through choice and through a kind of a mutuality, at least. And, you know, my fear is that the way contract law has been constructed and the way our contracts look, we're giving up this tremendous potential that we have to really change how people interact with one another. And so that's what yeah.
Any other
Thanks to all of you. That was very helpful.
Yeah.
As much as I look forward to developing my career as a legal artist, how much would you advocate for a standardization of images in contracts, or would that detract from your goal of getting people more invested in the parties thinking together?
Yeah. When I first started thinking about this, I had a project in mind that I would have a bunch of people, like in a wiki format, propose metaphors, visual metaphors for contractual terms or concepts. And then we would circulate it all over the internet, and people would kind of vote on it. And gradually, 10 years from now, the market would sort this out, and images would become much more prevalent. Some images would become much more prevalent in certain kind of contracts, and ultimately, right, standardization would be the outcome. I was convinced by a professional graphics designer that we shouldn't focus on metaphor, that metaphor has real limitations in the power of conveying information. And she is the one who designed, in partnership with others, those really great graphs at the end. And I was the one who designed those pretty primitive little icons at the beginning, okay? So should it be standardized? Not necessarily, but here's what's going to happen. I'm almost certain of this. There's a fellow in Australia who was a corporate in-house lawyer for 30 or 40 years, and he decided toward the end of his career to do a PhD in computer engineering. And he developed a program to automate the creation of charts and graphs in contracts. He set out a template where you ask yes or no kind of questions, right? And he's got all these algorithms. You as an attorney just respond to the content, and then you push a button, and the graph is created. So you don't need talent. I have no talent, that's clear. You don't need talent. It doesn't necessarily have to be standardized, but it will be automated and not raise transaction costs, because for real lawyers to use it, that'd be crucial.
To what extent? It sounded like the way I understood your use of visualization would be to communicate and get parties understanding what's happening, and to get them actually involved in something more deliberative as a democratic process of contracting and having a relationship. But I was curious, would you have one of those clauses the way some contracts do, when it says that, you know, we're using headings here for ease of understanding, but the headings have no meaning? Would the images have no meaning, no substantive meaning and import to the contract, such that they wouldn't be part of the interpretation? That's another panel, I guess Sean Barron left and others, but would they, or do they become part of the interpretive body of what is actual contractual in it?
Easy one. I would not have the images have any interpretive power. I think that muddles things too much. If we can get people to use the images to talk better, to use as a planning device, to help people implement contracts, they've done their task. And I think the words must predominate, because that's what law is ultimately based upon.
Anyone else? Yep.
I've yet to take payment systems, but why does it seems like our cards are a lot more susceptible to hacking than in other parts of the world, in Europe, Africa even. that's true, why are we not using their system?
That's a great question. If you look at the U.S. is really much further behind in terms of the types of payment mechanisms. So, for example, peer-to-peer transfers really became peer-to-peer transfers using cell phone credits became a form of liquid currency in Kenya and took off. So the company M-Pesa just completely dominated and reformed, and that's one of the places we get this idea of the way technology can transform. I mean, it's the perfect example of transforming a payments environment, because prior to M-Pesa, less than 20, it was something like less than 10% of the entire country kept funds in a single stored place, and after M-Pesa, more than 80% did, because everyone had access to a cell phone. They didn't have access to a banking system. I think one of the reasons that we see our system sort of lagging a little bit behind in terms of technology and some of the innovations on technology is simply because we have such a secure payments environment. It makes it harder for those payments environment to become conventional, right? And so then when things like Square Cash come that really are adaptive payment mechanisms that really draw upon the existing payments environment to create this means of transacting, now you're dealing with questions of, is this going to be convenient? Is it something that people will adapt? Do they have confidence in it? And so all of those questions come to bear, even though you might see, for example, the Target problem where, we had all of these various debit cards hacked. We still have a generalized confidence in the way we transact and exchange money, and that our remedies will provide some basis for ensuring that we're not going to be out thousands of dollars if somebody does hack our account. That would be the very short answer.